We have breaking, but sadly inevitable news. Special Counsel Jack Smith has just filed a motion to dismiss the federal prosecution against Donald Trump for election interference in light of the fact that Trump is about to become the president. However, in theory, there's some silver lining, which is that Smith has filed this motion in a way that if it's granted, it will at least leave the potential for the case to be resurrected against Trump in the future once Trump leaves office. Unless, of course, Trump pardons himself and the Supreme Court permits it. But before we unpack all that, if you end up liking this video and you want to support the channel, please be sure to hit the like, subscribe, and alert bells before you go. All right, friends, as I say, this is breaking but inevitable news. We expected that this would be the case, that the case against Trump would either be killed by Trump himself once he becomes president or by Jack Smith in advance. And in theory, this is actually a really smart move by Jack Smith because it leaves the possibility that the case could be brought in the future. We'll get into all of that, and we'll actually look at the motion itself because it is relatively short. But first, I want to give you the Washington Post breakdown for a quick summary before we get into the nitty-gritty. Special Counsel Jack Smith moves to dismiss Trump's D.C. prosecution. Smith asked U.S. District Judge Tanya Chutkan on Monday to dismiss the federal election interference charges against Donald Trump, putting an end to a lengthy investigation that never made it to trial. Smith's motion seeks to dismiss the case without prejudice. That's a key phrase, acknowledging that Justice Department policy prohibits prosecuting a sitting president. More on that later. If she does that, it leaves open the possibility that prosecutors could again bring charges once Trump leaves office after his second White House term. But legal experts said it's possible that once Trump is in office, he could try to do something that's never been tested before, pardon himself to foreclose the possibility of legal jeopardy in the future. Trump faces 4 counts related to conspiring to obstruct the 2020 election results. Smith's filing acknowledges that the Justice Department has long believed a sitting president can't stand trial, and says that prosecutors conferred with Trump's attorneys and that they did not oppose their request to dismiss the case. Quote, that prohibition is categorical and does not turn on the gravity of the crimes charged, the strength of the government's proof, or the merits of the prosecution, which the government stands fully behind, the filing states. Quote, based on the department's interpretation of the Constitution, the government moves for dismissal without prejudice of the superseding indictment. The historic case, which accuses Trump of pressuring state officials to change election results and denying the American people their right to have their votes respected, hit obstacle after obstacle since the August 2023 indictment. Trump's legal team filed a host of challenges, freezing the proceedings for months and winning a broad ruling from the Supreme Court that greatly expanded the legal immunity offered to ex-presidents for actions taken while they were in office. That's Trump v. United States, as a reminder, which is perhaps the worst Supreme Court ruling, certainly in modern history, and one of the worst in all of U.S. history, but I digress. Smith is expected to soon wind down a second Justice Department case against Trump, in which he is charged with hoarding classified documents in Florida after leaving the White House and obstructing government efforts to retrieve them. U.S. District Judge Aileen Cannon dismissed that case this summer, breaking with legal precedent to agree with Trump's lawyers. And by the way, Supreme Court Justice Clarence Thomas, who kind of threw Cannon a bone in Trump v. United States, that Smith was unlawfully appointed. Smith is appealing that decision, though he faces a December 2nd deadline to tell the U.S. Court of Appeals for the 11th Circuit how he will proceed now that Trump has been elected president. So I imagine if it's possible, he'll probably try to have that dismissed with prejudice as well, but I have no idea. So let's look into the actual filing itself. As a result of the election held on November 5th, 2024, the defendant, Donald J. Trump, will be inaugurated as president on January 20th, 2025. It's long been the position of the Department of Justice that the United States Constitution forbids the federal indictment and subsequent criminal prosecution of a sitting president. But the department and country have never faced the circumstance here, where a federal indictment against a private citizen has been returned by a grand jury and a criminal prosecution is already underway when the defendant is elected president. Confronted with this unprecedented situation, the special counsel's office consulted with the department's Office of Legal Counsel, whose interpretation of constitutional questions, such as raised here, is binding on department prosecutors. Now, this is the OLC, and the OLC, by the way, during President Nixon's administration, came to the conclusion they're the ones who've set this precedent, it's a 50-year precedent, that you can't indict a sitting president. And I should say, as much as I loathe presidential immunity, as much as I loathe this Trump v. United States decision, I will say this idea that, not prosecuting a sitting president while they're in office, there is a logic to that which makes sense. But again, we'll get into that. After careful consideration, the department has determined that the OLC's prior opinions concerning the Constitution's prohibition on federal indictment and prosecution of a sitting president apply to this situation, and that as a result, this prosecution must be dismissed before the defendant is inaugurated. That prohibition is categorical and does not turn on the gravity of the crimes charged, the strength of the government's proof, or the merits of the prosecution, which the government stands fully behind. Based on the department's interpretation of the Constitution, the government moves for dismissal without prejudice of the superseding indictment under the Federal Rule of Criminal Procedure 48A. The government has conferred with the defense counsel, who does not object to this motion. So again, what he's saying is, listen, we're not saying that this case sucks or that we're having second thoughts or that we don't think that the crimes are grave. We stand by everything we said, but we recognize that once he becomes a sitting president, he is effectively immune from prosecution until he leaves office. That's it. That's all this is. They concede nothing else. And so we're not going to read the rest of it, other than I will point out again, the government's position on the merits of the defendant's prosecution has not changed, but the circumstances have. As a result of the election, the defendant will be certified as president-elect on January 6, 2025, and inaugurated on January 20th, 2025. This sets at odds two fundamental and compelling national interests. On the one hand, the Constitution's requirement that the president must not be unduly encumbered in fulfilling his weighty responsibilities. And it cites Nixon v. Fitzgerald, which is perhaps the only major precedent that Trump v. United States cited, I will point out, even though it deals with civil liability. Quote, the president occupies a unique position and is, quote, entrusted with supervisory and policy responsibilities of utmost discretion and sensitivity. And on the other hand, the nation's commitment to the rule of law and the longstanding principle that no man in this country is so high that he is above the law, U.S. v. Lee. Given this unprecedented circumstance, the special counsel consulted with OLC, which by delegation of the Attorney General provides controlling legal advice to the executive branch, including the department. Again, as far as the executive branch is concerned, the OLC's legal opinions on constitutionality are binding on the executive branch. Some other things I want to point out here. In 2000, in the wake of the first presidential impeachment in more than a century, OLC issued a second opinion revisiting the question of whether a sitting president could be criminally charged, and again concluded that charging and prosecuting a sitting president would impermissibly threaten the constitutional separation of powers because it would harm the president's ability to fulfill his constitutional role. The 2000 OLC opinion reasoned that prosecuting a sitting president would risk imposing three burdens that would make it impossible for a president to effectively carry out his constitutional duties. Number one, the burden of imprisonment, which would physically prevent the president from doing his work. Number two, the burden of public stigma and opprobrium, which would weaken the president's ability to, quote, fulfill his constitutionally contemplated leadership role. And three, the mental and physical burdens associated with preparing a defense to a criminal prosecution, which might severely hamper the president's performance of official duties. So again, I say, as somebody who does not like Trump, as somebody who thinks that Trump is guilty, as somebody who does not value at all and categorically rejects presidential immunity for any president, Trump, Biden, Obama, Bush, Clinton, it doesn't matter. I do understand the temporary protections afforded to a sitting president. It does make sense. Both the 1973 and 2000 OLC opinions recognized the critical national interest in upholding the rule of law and stated that the president is not above it. Recognize that the president is not above the law and that he is ultimately accountable for his misconduct that occurs before, during, and after his service to his country. The framers of the Constitution made it abundantly clear that the president was intended to be a chief executive, responsible, subject to the law, and lacking the prerogatives and privileges of the King of England. This separates presidential immunity, or even temporary presidential immunity, which is what the OLC offers, from something like sovereign immunity. Sovereign immunity is what the King of Great Britain, what King Charles, the current King of Great Britain, he enjoys. He is above the law. He is, as far as British law is concerned, King Charles literally could go out and shoot someone on the London equivalent of Fifth Avenue and not be prosecuted because he is the crown, and the crown is the source of law. He is sovereign. Presidents are merely chief executive, and that's part of the reason why this notion of presidential immunity is so un-American and is so gross, because it rings hollow. It contradicts everything that we've envisioned for our presidents, who are incredibly powerful and incredibly important, but temporary and elected and accountable not just to the law, but to you and me and to the voters. Again, I don't want this for anybody, and that's why it's so gross to hear Trump supporters in particular, because they're really the nexus of it. Like, yeah, presidents should have absolute immunity, should have sweeping immunity. You guys want a king. You were just horny for a king, and your king in particular. You would never want that if President Obama or President Biden advocated for the same thing. But again, I digress. OLC has previously considered the possibility that the harms to the presidency might be ameliorated by returning an indictment against a sitting president, but holding subsequent proceedings in abeyance until his term expires. And this is what the hope is. The hope is that they basically will pause the notion of statutes of limitation for 4 years. Like, you're basically not allowed to run the clock. This is what the case that Jack Smith is hoping to make. And he is citing that the Office of Legal Counsel has opined in that direction as well, which is like, if the president commits a crime in office, you still can't prosecute them while they are in office, but we pause it. And as soon as they leave office, they are fair game. One of the fears is that the clock will continue to run, even if this motion is granted, such that it may affect the outcome of the case once Trump leaves office. It could be that the statute of limitations for Trump's misconduct or the alleged misconduct may expire. Now, that I'm not sure of, but there's a reason that Jack Smith mentioned this in his case. He's like, hey, listen, the OLC says in a situation even similar to this, they're hoping that the proceedings are held in abeyance, which is a suspension. It's a pause until the term expires. We'll see what happens. While the 1973 OLC opinion did not reach any conclusion on this question, in 2000, after balancing the competing interests that would arise from a federal indictment brought against a sitting president, OLC concluded that, quote, a sitting president is immune from indictment as well as further criminal process, and that the Constitution would thus prohibit an indictment even if all subsequent proceedings were postponed until after the president left office. So they're saying that you can't indict the president. The motion has to be dismissed. So in other words, what they're saying is that the 2000 OLC update opinion says you might be able to bring charges after they leave office, but you can't prosecute them now and just say we're not going to do anything until they leave office. There can be no indictment against a sitting president. So if there is one already, you have to dismiss, which is what Jack Smith is doing here. But they leave open to this idea that you can bring up charges in the future. That's, again, the hope. Neither the 1973 nor the 2000 OLC opinion addressed directly a federal indictment that has already been returned against a private citizen prior to his election as president. The special counsel's office therefore sought the OLC's guidance on whether this case must be dismissed or whether the pending superseding indictment against the president could be held in abeyance until he's no longer immune from prosecution. OLC concluded in its 2000 opinion categorical prohibition on the federal indictment of a sitting president, even if the case were held in abeyance, applies to this situation where a federal indictment was returned before the defendant takes office. Accordingly, the department's position is that the Constitution requires that this case be dismissed before the defendant is inaugurated. For foregoing reasons, the government respectfully moves under Federal Rule of Criminal Procedure 48 subsection A for dismissal without prejudice of the superseding indictment. All of this is to say that Jack Smith is throwing in the towel for the most part, saying we're going to dismiss the indictment. The Constitution doesn't permit it. The Office of Legal Counsel doesn't permit it, but we're dismissing it without prejudice. What that means is, in theory, the case can be resurrected against Trump once he's no longer prejudiced. Now, if they requested dismissal with prejudice, they're basically breaking the key off in the lock and saying it's done, it's unresurrectable, we are just burning the bridges. And this is part of the reason I suspect why Jack Smith is doing it himself rather than waiting for Trump to fire him and having, his new attorney general, whoever that would be, to order the case be dismissed with prejudice, right? If Trump's attorney general dismisses the case with prejudice, then Trump wouldn't even have to pardon himself or even attempt to pardon himself, because it would be the executive branch just destroying the case, not just destroying this, not just dismissing this particular case, but doing it in a way where it can't be brought up in the future. Jack Smith is trying to preempt that. The second question is whether or not there will be any sort of pause in statute of limitations, if that would be held in abeyance because the president, Donald Trump, would become president, right? And then the third question is, even if all of this isn't an issue, perhaps the statute of limitations won't be unduly affected and that Trump would be eligible for indictment. The statute of limitations wouldn't expire after he leaves office. But what if he pardons himself? And this is part of the real danger. So the Supreme Court of the United States in Trump v. United States, what did they say? Well, that the powers of the presidency, like a core constitutional function, are unreviewable by the court. They are absolute. So technically, the pardon power doesn't offer any caveats. The Constitution is silent on this notion that the president Like, it doesn't offer any qualifications except for the only cases that the president can pardon somebody for are for federal charges, right? That's the only qualification. The president can't pardon somebody for state offenses, for example, only federal prosecutions. But it doesn't say that he can't pardon himself or that he can't pardon this person or that person. If you just read the text, one assumes it's an absolute power. Now, there's this legal notion that nobody can be the judge in his own case, right? That's this idea that, it's a longstanding legal precedent, not just here in the United States, but it's part of the legal tradition of just Western democracies and Western nations as a whole, including, again, Great Britain. But it's not written in the Constitution. So you could get, I would argue, a very bad faith originalist or traditional saying, yeah, of course the founders intended for the presidency to be a get out of jail free card, and a criminal president could snap their fingers and pardon themselves. Why not? Otherwise, they would have written it into the Constitution. So I think there's a very real risk that Trump will pardon himself. And I think there's a very real risk that if it's litigated and makes its way before the United States Supreme Court, that the Supreme Court will effectively permit it. But we can't control that. In the short term, and Jack Smith certainly can't control that. He has played his cards to the best of his ability. He is preempting a dismissal with prejudice by filing for a dismissal without prejudice. And there's a hope that if it's granted, it could be resurrected, this case, that is, against Trump in the future, or at least remade from scratch. Fingers crossed, folks. This is where we are. In the meantime, let me know what you think in the comments.